Donald Trump drops the final mother lode of dismissal filings in Florida in Judge Cannon's courtroom, and 3 of them we can't see yet, but apparently they're going to be dropped on the docket at some point in time, and there are some good things that we expect to see inside. But today we're going to be talking about the motion to dismiss based on presidential immunity, and Trump does a nice job here of saying, you know, Judge Cannon, even Jack Smith admits that these documents that were taken, so-called in Florida, they were taken during the presidency, which means the taking of the documents were presidential acts, which means those presidential acts are subject to presidential immunity, which is currently at the Supreme Court on review. So we'll see what's inside. We'll hear from Ted Cruz and Crazy Eyes Griswold on how dangerous Trump is. But let's just take a look at what is coming very soon. We cannot wait to see what is inside these filings, but they're not here quite yet. This came out from Trump's defense. You can see very short notice, right? It's not the actual filings, but it's just a notice. They're saying, hey, Judge Cannon, in the West Palm Beach Division in Florida, the classified documents case, here's a little taster for us. Says Trump respectfully submits this notice saying that after conferring with Jack Smith, who's illegal, we are providing public notice that President Trump is submitting 3 unredacted reply briefs to the court and counsel of record via email. Now, this stuff is not on the public docket yet. The 3 reply briefs relate to the following motions, which have not yet been docketed. But look at this juicy, meaty meatball. Says motion to dismiss the superseding indictment based on selective and vindictive prosecution, saying Jack Smith has targeted Donald Trump and the case needs to be dismissed. It's not on the public docket because we can't see it yet. Motion to dismiss the superseding indictment, or in the alternative, to suppress those 15 boxes. Why? Prosecutorial misconduct resulting in due process violations and impermissible pre-indictment delay, right? They dragged this thing out for multiple years until an election season. And grand jury abuses, all good stuff. And also a motion to suppress evidence that was seized during the raid at Mar-a-Lago that was all obtained in violation of Trump's attorney-client privilege. So boom. And dismiss the superseding indictment based on prejudice from this privilege violation. 3 separate replies that we will not see here today, but they should drop at some point, and when they do, we'll be excited about it. But we do have some more fun stuff to get into, including the presidential immunity issue. This one was signed by Emil Bove and Christopher Keese. They're handling the cases down in Florida. But here was the other submission that came in that is available on the public docket, and it is pointing back to Jack Smith's own words. Donald Trump's reply brief, which is the final motion on this issue in Cannon's courtroom. So Trump's motion to dismiss counts 1 through 32. Jack Smith responds. Donald Trump replies to Jack Smith's response. Here's what they say. In their response in Judge Cannon's courtroom, they say, Your Honor, Judge Cannon, Trump is here now, and he is submitting his reply. We want to tell you that Jack Smith is wrong about the law, right? This is the same guy that argued that this law was so-called clear when it's not clear. As we know, that's up on review. They now claim, Jack Smith, who's been wrong about other things, he now claims that a motion based on an issue of first impression, which is called presidential immunity, never been decided before. He says that that issue is currently frivolous, which is weird, which is in an effort to avoid any necessary appellate review. So it's not frivolous, right? Because the Supreme Court has it. So Jack Smith is wrong. But if nothing else, you know, these prosecutors are consistent in being wrong, consistent in their willingness to say and do everything in their power to try to rush this novel and this flawed case to trial. There are legal issues that are complex. There are ongoing discovery violations, but they persist, all in support of Biden's election interference mission against his leading opponent, Trump. They say, Judge Cannon, you know, this timely motion to dismiss is not frivolous. It's not dilatory. It's based on allegations in the indictment and other subsequent concessions by Jack Smith himself. We know that counts 1 through 32 are based on Trump's official acts during his first term in office. And so, because they're based on his official acts, the counts, of course, are the removal of the documents, saying accordingly, the court should hold this motion in abeyance, pending the Supreme Court's review of immunity, and stop this case until we get decisions there. Trump's defense says, Your Honor, Judge Cannon, you should hold this case, put it on pause. After Trump filed this motion to dismiss, as the court is aware, SCOTUS accepted the case, asking the question, very important question, which we're scheduled for oral arguments on very soon, says whether, and if so, to what extent does a president enjoy presidential immunity for crimes alleged to have occurred and involving official acts during his tenure in office? Supreme Court's going to be deciding all this. Trump filed his opening briefs, arguments scheduled to occur this month on the 25th, and so you should stay this case. Here's why. Jack Smith and their office, they're seeking to dodge the entire issue. Now, they claim that counts 1 through 32 are not based on official acts. But that argument would require the court to rewrite their indictment, which is a difficult thing to do. As we saw with Fannie, hard to do that. Judge just dismisses charges, So here's what they did wrong. Now, the time frame for each alleged of counts 1 through 32, it begins on January 20th, 2021. The indictment, count 1 through 32 on January 20th. Now, President Trump was commander-in-chief until noon on that day, officially. Now, as alleged by Jack Smith's office in their indictment, Trump allegedly made the decision to retain the documents in question by causing them to be removed from the White House while he was allegedly still president. In fact, they said that in their indictment themselves. According to the superseding indictment, the decision allegedly occurred, in other words, the decision to move the boxes, was done as Trump was preparing to leave the White House, when Trump, quote, and his White House staff packed items and that the office believes, quote, contained hundreds of classified documents. Their quotes, not ours. In 2 court filings in this case, the office has conceded that these alleged decisions occurred during President Trump's first term, during the term, not after, and that the genesis of the case dates back to, quote, the tail end of the Trump administration itself. These are the prosecutor's own words. So when President Trump allegedly made the retention decision, he did it as the president. He did so with the authority to designate those records as personal. Your own indictment says that he did this stuff at the end of his presidency on January 20th is when you said it happened. He did so with the authority to do that. He could declare these documents as personal under the Presidential Records Act, just like Bill Clinton did. He had the ability to also declassify these records pursuant to Article 2 of the Constitution and the various executive orders. These decisions within the outer perimeter of official responsibility. Trump also made a statement back on July 26, 2018, about the termination of John Brennan's security clearance, which the office improperly seeks to use against Trump in pretrial motions. Now, President Trump is entitled to every opportunity to prevent official acts evidence from being used against him at trial, and the court must preclude this evidence, right? If they're official acts, they're protected. Court can't talk about it. So therefore, counts 1 through 32 should be dismissed following the decision in Trump versus United States, because these counts are based on the official retention decisions that Trump made as president. And moreover, there's evidence of President Trump and their official acts. It's not admissible at any trial, should one be necessary on the remaining counts. In this other case called Johnson, SCOTUS held that in a case involving a criminal statute of general application, prosecutors could not draw in question the legislative acts of the defendant member of Congress or his motives for performing them under the speech and debate clause. Same concept here applies. The underlying charges don't support the main charges, saying this motion is not frivolous as well. Hey, Judge Cannon, wrongfully assuming a victory in the Supreme Court and on this motion, Jack Smith and their office asked this court to designate this motion as frivolous so that we can't appeal this. Now, this is not the first time that the office has sought to deny Trump access to appeal rights, but this is the most recent attempt. In fact, Jack Smith made a similar request in D.C., but the court did not find that Trump's immunity motion, which is now under review at the, Supreme Court, they didn't find, even Chutkan didn't find that that was frivolous. Here, Jack's argument is based on the false claim that counts 1 through 32 entirely post-date Trump's term in office. But as noted, right, so Jack Smith, in other words, is now saying, no, this all happened after the presidency. But no, his own charging document, paragraph 4, paragraph 25 of the indictment itself, and written assertions by his office and other filings acknowledge that the theory of the case is based in part on alleged actions, that the decisions to retain the documents occurred at the tail end, and they say at the 11th hour of Trump's first term. So now they want to change their theory. Sorry, you already indicted him. Finally, cases like Dunbar and its progeny only support a narrow exception to the general rule about appeal rights, talking about, interlocutory appeals and this exception. So don't call it frivolous. Now, for the foregoing reasons, the court should hold this motion in abeyance pending the Supreme Court decision on immunity when they decide, signed by Todd Blanche and Christopher Keese. And so this is going to go to Judge Cannon now, right? We have the final sandwich has been made, Trump's motion, Jack Smith's response, Trump's final reply. So it'll go up to Judge Cannon and we'll see what she says on it when the ruling comes down. down. But we've got a lot of stuff that Cannon is considering: selective vindictive motions, suppressing for misconduct, attorney-client breaches, now official immunity. And of course, they are very concerned about Trump's seeming success. Every time they indict him or try to remove him from ballots, Trump seems to get a little bit stronger. And so they are still bringing out the TDS secretaries, and they include Griswold, Shenna Bellows, Jocelyn Benson, and many others. But here is the Secretary of State, who's going to be running the scoreboard during the election in 2024. Here's what she says in response to Trump's success and rise.
To be very clear, the two men who were prosecuted were not part of this current threat barrage. I started to receive threats in 2021 after the insurrection, and they go up and down. Of course, with the Supreme Court case, when it was filed in September, we saw a huge uptick. But the bigger picture is that many of these threats are not taken seriously. Secretaries of State and election workers are told repeatedly that when people say they're going to hang us, kill our families, that the threats aren't real. We consistently have to fight for sufficient security. And you just have to look at the rate that the DOJ's Special Task Force on Election Threats to Election Officials. They have only prosecuted 20 cases since 2021. So there is a definite feeling among secretaries of state and election officials that this is not a serious matter for many. And I would just like to clearly state to federal and state officials and to the DOJ that it is time to wake up. Again, no one should have to live in this type of atmosphere. Election workers, when they're threatened, they're just largely volunteers. And it is ridiculous that we are not seeing more prosecutions in this country and more invested in the security of election officials and secretaries of state.
Yeah, so she's a victim. She's constantly under attack, always being harassed, and she needs more people arrested to provide for her safety and her security. And again, I've made the point here many times, right? Actual threats, real threats, they investigate. You know how I know that? Because I've represented people on the other end of this conversation. And it is a very, unfortunately a common thing, right? People will get drunk, they'll send off a text message, they'll send off, a phone call, leave a voicemail, whatever. And it is investigated, and the serious stuff, right, that actually, has some legs to it, they investigate, they arrest people, they charge them with crimes. Now, I don't know what they're doing in Colorado, but in Arizona, they certainly do. And, they don't play around with this stuff, which is why I'm always very, very concerned when Joe Biden shares his text messages, right? Send me a text, Dementia Joe. You're like, oh gosh, don't text him, okay? It's a trap, 100%. So, I don't know what her concerns are. She probably, has a shadow and she's freaked out. I'm under attack. Is that MAGA again? So, you can just see from her eyes, she's hysterical. She's crazy eyes Griswold, and she's petrified. So more people need to be arrested. The arrests will continue until Jenna Griswold feels safe and satisfied. All right, here's Ted Cruz, who's confirming, all this stuff, all these secretaries and all these people, they are causing the greatest assault on American democracy that we've seen in our lifetimes.
John, you are absolutely right. What we are seeing across the board in the legal system is the weaponization of our legal system. In over 2 centuries of our nation's history, a president has never been indicted, a former president has never been indicted. In just over 1 year, Donald Trump has been indicted 4 times by partisan Democrat prosecutors who hate his guts. On top of that, you have the ridiculous civil lawsuit by Letitia James, a partisan Democrat who ran on the promise to, quote, get Donald Trump and got a $450 million judgment against him. She wants to take $500 million from him for an offense that injured nobody, that there was no harm, and that the supposed victim who made money on it were giant international banks. It is absurd. And here's the most important thing to understand. It is not just that Democrats hate Donald Trump. They do, to be sure. But the real target here is you, the American voters. This is an assault on democracy. And Democrats love to beat their chest and say we're defending democracy. But the reason all of these cases are being brought is because Democrats are terrified that the voters in November are going to reelect Donald Trump as president, and they're trying to bring the entirety of the legal system to stop the voters. This is the greatest assault on democracy literally in the history of our country, and we're seeing it with every elected Democrat quietly applauding and celebrating this assault.
He's absolutely right about that. When Ted delivers, man, he can deliver, and that was a good one there. I think he's right, and we made the point here many times that without a functioning justice system, there really is no country. You know, the justice system is speed bumps against tyrannical control by one party or another. Stop the tide from shifting too far blue or from too far red. But now we're watching the full creation of campaign strategy built around the courts. Prosecute Trump, sue him, remove him from the ballots, right? Beat him in whole new arena. This is not, you know, beat him in commercials on TV. It's not beat him on social media. It's not have a better debate for him, right? It's use the system to take him out because they can't beat him anywhere else. So we're going to be here continuing to cover it. We'll see what Judge Cannon does on this one. I think perfectly within reason to have her stay everything until SCOTUS decides, and we'll see what SCOTUS says. So we'll be here continuing to cover this, my friends. Thank you for subscribing. Thanks for liking this video and joining us whenever we go live. Of course, we're covering this case, the rest of the Trump prosecution, so we appreciate you inviting a friend or family member to come on over here and join us so they can also see what the heck is going on inside of these cases. We got great links down in the description below, an amazing members-only community where we talk about some other stuff like what's happening in 2024 and elsewhere. We'd love to see you there and back here on the next one.